everybody, welcome again to our roundtable conversations. And today we're going to be discussing assisted suicide. Should it be legal? Should not be legal? Some people know it as euthanasia. Our goal, our mission statement in the roundtable conversation is, as always, to spread and practice the art of listening. Our rules in order to promote that are that all our participants are equal in importance. One person speaks at a time. When not speaking, we listen. We try to understand other speakers. We don't argue with other people. We just add to the common pool of meaning. We don't negate. We don't argue. And we talk according to the question being considered, and we take into consideration everybody's attention spans. So that's about it. So great topic today. Today we have Stephanie Woodward, David C. Leven, Gerald Dworkin, and Joanne Lynn. So our first question of the day is, tell us a little bit about yourself and how you got interested in this issue of assisted suicide. And David, could you please start?
Lawyer by training, graduated 50 years ago from law school. I've always done public interest law, always seeking justice for the clients that I've worked for. I was in legal services for the poor lawyer for 10 years in Rochester, serving poor people. I was Executive Director of Services 20 years, and then for the past 16 years, I've been working on end-of-life issues. On all of these issues, on all of the issues that I've worked on for the clients that I've worked with, we are seeking justice and fairness for those people, whether it's poor people, prisoners, or patients. And with regard to patients, when it comes to the topic we're talking about tonight, which we call medical aid and dying because we don't think it's a suicide, this is something which is extremely important because unfortunately, not all end-of-life options are successful in protecting and ensuring that people have good deaths. And so the option of medical aid and dying is essential as a new option, which is now available actually in 7 states and the District of Columbia, constituting about 20% of the nation's population. And the laws have worked extremely well in those states which have authorized medical aid and dying.
Gerald?
Hi, I am a philosopher. I specialize in particular in moral and political philosophy. And when I began teaching, I was asked to teach a medical ethics course. I had never had any particular training in that area, and I had to sort of bone up. And I became quite interested in various issues in medical ethics. I did not get interested in the particular issues that are discussing us today until fairly late in my career. And this was not only late in my career, but later in my life. And I'm sure it had to do with the fact that I was getting older, and I knew, unfortunately, that like everyone else, I would die. And I became interested in various issues about death and dying. So I would say I was interested in the question just as a general theoretical issue. And I was interested on a personal level. And in the last few years, since I was teaching in California, and California was involved in legislating the Medically Assisted Dying Act, I became interested politically and worked in various ways to achieve its success. I think that it's very important at the beginning to be clear about the terms we use in this discussion. It was introduced as assisted suicide, and it was said that some people call it euthanasia. I want to make clear that, at least as far as I'm concerned, it is certainly not euthanasia. However euthanasia is defined, it will have as one of its characteristics that someone kills someone else, and medically assisted dying does not involve that. And secondly, although I myself was a co-author on a book called Physician-Assisted Suicide, Pro and Con, I took the pro side. it has now become politically a term that should not be used. That is the notion of suicide. I personally disagree with the ban on the term. I think suicide is something that can be discussed rationally and carefully, and one shouldn't avoid it simply for political reasons. But it's no doubt the case that it makes it harder to get such legislation, which I am in favor of. And so all of the bills that have been introduced have been phrased now in terms of medically assisted dying. And that is, at least on this program, how I shall refer to the topic.
Joanne?
Hi, I'm a physician, a geriatrician. That's a person who takes care of elderly people. I was one of the first hospice physicians back in 1978. I've worked in ethics. I was the author of the President's Commission on Ethics in Medicine report called Deciding to Forgo Life-Sustaining Treatment. I've written chapters in most of the medical textbooks on how to take care of people who are close to death. I worked in public health and at the Centers for Medicare and Medicaid Services, the CMS that governs much of the financing of people who are coming to the end of life. It's now the case that more than 90% of us die covered by Medicare. I've now work mostly on reform, trying to make it safe for people to grow old with confidence and with appropriate services. The aim is to make it possible for people to live meaningfully and comfortably through to the end of their days. I am against the legalization of whatever it is Jerry and David want to call it. In this world at this time, there are such enormous disparities in what's available to people. The usual person now coming into old age is desperately poor. And we make so few options available for that person that they may exercise their, quote, choice, unquote, to foreshorten their lives in order to leave some financial benefit to a spouse or children, in order not to lose the farm, in order to have food up until the day they die. We have waiting lists for food in most major cities that are more than 6 months long. In a world in which that's the disparities, making it available for very sick and disabled elderly people to, quote, choose, unquote, to be dead may be a quite false choice. And if we had adequate support for people who are facing the prospect of having to live with serious illness and disability, then I might see it very differently. But at the present time, I think that it will take some time, but eventually there will be people who are selecting this option because the other options are so grim, and they are grim in ways that we could have fixed but didn't choose to.
Thank you. Stephanie?
Hi. I am also, like David, a lawyer by training and have always worked in the public interest field. And I am also always seeking justice for specifically the disability community. I am a proud disabled person and got specifically assisted suicide issues when discriminatory, disparate impact that it has on disabled people, and a deadly impact, because a lot of the reasons that we're seeing cited for desiring suicide, physician-assisted suicide, has nothing to do with pain, but rather through disabling conditions. Important for us to recognize that disability is not a reason to die, and it shouldn't be a reason that we are promoting a choice to die, because when we are not providing disabled people the resources they need to live, not choice. So I think that for me and the disability community at large, until we have full equality, we shouldn't be given a law that legalizes our death and have it be called a choice.
Thank you so much. So these are our speakers for today. And the first question that I want to present to you is, do you think that human life is sacred, precious? What makes it so? And do you think that people's free choice is sacred, precious? Is their personal agency sacred and precious? So David, take it away.
Life is absolutely precious, and most of us live as long as we possibly can until such time as we are suffering to such a great extent that we feel we can no longer continue to live. And so people do have choices at the end of their lives. People can withdraw life-sustaining treatment. They can never start life-sustaining treatment which could keep them alive for weeks or months. That is a choice which people can and do make. And so while I agree with Joanne about the disparities issue, we have terrible disparities. The experience in the states which have medical aid in dying laws shows very clearly that those people who take advantage of those laws are people who have a good education, people who do have health insurance, people who are making this choice after a thorough, thoughtful process involving at least 2 doctors, almost always family members, and in consultation with them. And the process ordinarily takes 7 weeks. And it is so much different than suicide. So while life is precious, there does come a time when many people will decide to shorten their lives by withdrawing life-sustaining treatment, or possibly by voluntarily stopping eating and drinking, which appears to be a legal option in this country now, as it has not been challenged, and the medical aid in dying option really is not a suicide. There are stark differences. Suicides are committed by those who could continue to live but choose not to. They're done in isolation, often impulsively and violently, and usually people have a mental illness, and they're tragic. To the contrary, medical aid in dying is available only to terminally ill patients who will soon die. The process usually takes at least several weeks, as I said, and it almost always occurs after this consultation that I mentioned. And the term assisted suicide is actually rejected by the American Public Health Association, the American Academy of Hospice and Palliative Medicine, the American Medical Women's Association, and the American Association of Suicidology, which actually issued a statement which is entitled "Suicide is not the same as physician aid in dying." So I think it's really inappropriate to continue to call this physician-assisted suicide or assisted suicide, especially when what must happen is that the patient must self-administer the medications him or herself if he or she decides to do so. And the other thing I'll say about this in terms of the disparities issue, and I think it's very important, we need to provide more and better palliative care and hospice, which are excellent when they're provided. But that's, again, not the reason why people are using medical aid in dying. In fact, they are over 90% of people who access medical aid in dying in Oregon are actually receiving hospice care.
Thank you. Gerald?
Well, I'm tempted to just say what he just said, but I'll try to add a bit to the general theme. I think it's important because both of the speakers who are opposed want to make claims that there are harms, that there are dangers involved in this legislation. And I think that in general and in theory, those are perfectly legitimate arguments to make. We make them all the time about laws that we don't want to see enacted. But I recognize that if one is going to claim that there are harms, then there has to be empirical evidence that, one, these harms are in fact harms as opposed to something else, and two, that they are in fact likely to come about. And so I think it's very important for anyone thinking about this set of issues to look at the state of Oregon. The state of Oregon has had a medically assisted dying law for more than 20 years now. As part of the law, the Oregon state was enjoined that they must keep statistics, study what happened as a result of these laws, and publish a report every single year. That report lists how many people were prescribed the medication, how many people took it, how many people died, and among other things, it reports socioeconomic statistics. And if you look at the state of Oregon, you find there is a certain inequality. The inequality is that 94% of the people who use it are white. And I agree, that is not a good situation. But as opposed to Joanne's worry, I want to get more minorities and non-white people to take advantage of a law which allows them to help with their suffering at the end of life. The second thing is the original question that was asked, is life sacred? Is life precious? I think we all agree that it is. I think we also all agree that there are times when it's appropriate for individuals to get themselves into positions where they're going to die sooner rather than otherwise. For example, a soldier who sees a live grenade thrown into the midst of his comrades may throw himself on that grenade in order to save their lives. Was his life not sacred? Of course it was. But did he do this in a thoughtful manner? Did he do it for a good reason? Did he do it to produce some good in the world? He did, and he's honored. He's not condemned for doing this. Now, I'm not asking the same kind of honor be given to those people who take advantage of medically assisted dying. The law simply says, look, you are the one who has to decide when and for what reason you want to end your life. There are plenty of alternative ways of doing it. For example, as was mentioned.
Let's try to wrap it up, Gerald, because you're time up. Okay, so I'm reminding us the question at hand is human life sacred, precious, and what makes it so? And is people's free choice, their personal agency sacred? And one of the rules is we try to focus on the question at hand. So Joanne, please take it away.
Well, the language you choose is natural to many people, but not all. I think Jerry's right that that everybody agrees that life is precious. Whether it is sacred depends upon whether you have a sense of an almighty, of a religious force, and not everybody would agree with that. But obviously, this is what we've got, and we don't have alternatives. So it is precious in the way that something that is a very limited resource is considered to be very precious. So, of course, life is precious, and yet it will end. It is, a one-act drama. We don't get to come back, or at least in any ordinary way. I know some religions believe you come back, but certainly not in the same body, in the same context. So, of course, it's precious. That doesn't particularly answer anything. The fact that you will get, in general, very ill and then die makes it reasonable to cut that short. And as Jerry and David have pointed out, you can cut it short in all kinds of ways. You can cut it short by stopping eating and drinking. You can cut it short by stopping your insulin, or by refusing to go to the hospital. Or, people sick enough to die generally find a way to die if they are not kind of buttressed back into life. But the thing I can't deliver on without the legalization is I can't make it happen tomorrow at 10. I can't make it a planned event. The only thing I can't do is to make it a planned event. So living with the uncertainty of how long you will linger, for some people, is very annoying. For other people, it's just the price of being a human, and it's not a big deal. It's rarely symptoms that are pushing people into choosing to end their life early. It's sort of fatigue, being weary with the world, having finished your life tasks as best you can. It's not usually some overwhelming pain or something like that, because we can treat those.
Thank you so much. Steph?
I would agree that life is precious. I'm not sacred, just because I think that's a bit too religious for my expertise. But I do believe that not only is life precious, but we need to emphasize that all lives are, and all lives have the same value, meaning that disabled lives should not be devalued by being described as undignified. When we use terms like death with dignity, we are saying that lives are undignified if they're lived in a disabled way, which is simply not the case. And I do believe that it is important for each individual's autonomy and rights to make their own choices to be respected. And I also believe it's important all individuals are offered choices. And with the legalization of assisted suicide, we're not offering everybody the same choice. We're offering a specific subset of people who experience disability that choice. And it is not limited to people who are terminal. In fact, in some cases, defined as a certain time limit to live without treatment. As a disabled woman who regularly infections, I can tell you if I not to treatment for that kidney and without a doubt result in my death within 6 months. That spreads quick. That doesn't mean I am terminal. I am a healthy disabled person, but these laws would allow me to do a standard. This is not about just this is about disability.
Thank you, Stephanie. So our next question is as follows. If we allow suicide under certain conditions, under certain auspices, if we allow suicide under certain conditions, under certain auspices, doesn't it ultimately lead to allowing it in all circumstances? And we have the example of Belgium that in the 90s, I believe they legalized suicide. And these days, there's already been cases of suicide being authorized for somebody who lost their vision, and just for people who are old and depressed or tired of life. And it's been made legal, although it hasn't been enacted yet, for people underage to also apply for permission to end their lives. So the question is, if we allow suicide under certain auspices, does it not ultimately lead to allowing it in all circumstances? David, take it away.
The answer is absolutely not, at least in this country. There's no evidence whatsoever that there is any movement at all towards expanding medical aid in dying for those who are not terminally ill and likely to die within 6 months. In fact, it is extremely difficult to get laws enacted in this country to allow medical aid in dying just for adult terminally ill patients with mental capacity. Only 7 states, as I mentioned earlier, have allowed medical aid in dying, and the District of Columbia. And unfortunately, while the public supports medical aid in dying by a very significant margin, in most polls by over 60%, as well as a new poll, at least from New York, showing that doctors support the Medical Aid in Dying Act by a 3-to-1 margin, and across the country by a 2-to-1 margin. Doctors support medical aid in dying. Their legislatures are divided politically on this issue, even though the public is not. And so when this issue for legislatures, while most Democrats vote for medical aid in dying bills, virtually all Republicans vote against medical aid in dying bills. So to suggest that just because laws have been expanded to apply to people who are not necessarily terminally ill in certain countries in Europe might result in that same kind of expansion in the United States, I think is foolish, and there is just no realistic expectation that that might happen. It's speculation, it's fear-mongering amongst those who are opposed, and they do raise this issue, which you have raised with us, I think, appropriately for discussion. Joanne,
if you could address the question.
You know, The experience in Oregon has been generally okay. There has been one family member who clearly suffocated the person when the drugs didn't work as quickly as expected. There's been another kind of conflict of interest case, but those are reasonably rare. But Oregon is also watched very closely. I don't think that we would have the same track record in Newark. I don't think we'd have the same track record in Miami. I think that the experience in the Netherlands and Belgium is very troubling. That you begin to have the suffering from the loss of a child as sufficient reason. And it's interesting that we have never actually defined the idea of terminal illness. It sounds like it's nice and crisp, likely to die within 6 months. How likely? Does it have to be sort of 99% likely or 51% likely? That sounds like, kind of arguing about the number of angels on the head of a pin until you realize that in the case of frailty and old age, that's a 1,000-fold difference. For every person who's eligible at a 99% likelihood, that person is likely to die within a couple of days, not enough time to even get all these pieces of the legal stuff done. And if it's 51%, we have 1,000 people who would be eligible. It's a huge difference, and we've never been willing to even try to define exactly how certain you have to be. In the support study in 1990, it turned out that 50%, that a person who actually dies today, a week earlier, had a 50% likelihood of living 2 months. A person who is dying with renal failure today had a 50% likelihood of living 6 months. So, the idea of terminal illness and the statistical definition, which sounds so nifty and crisp, is actually terribly difficult to apply in any consistent fashion. So, we have to really worry about what these boundaries are likely to be and likely to sustain, especially in the presence of an oncoming onslaught of very poor elderly people.
Thank you. Gerald?
I agree with Joanne about the problems of defining terminal illness. But it's important to note that terminal illness does not only appear in legislation involving dying, assisted dying, it appears in the regulations of Medicare with respect to hospices. Hospices require that a doctor make a prediction that you're terminally ill in order to be admitted to a hospice. So, it's a general problem. And I think that perhaps we have no better way at the moment of doing much about sharpening up the definition. I believe there's a study that shows that doctors are not very good at predicting when people die, that in fact, if you flipped a coin, you'd probably get, on the whole, a more accurate answer. But the second issue is the general question of how to think about predictions about possible harms. And this is the famous or infamous slippery slope. The idea is that, as some cynic once put it, once you do something good, it may be the case that by consistency, you'll have to do a lot of other things that are good as well. It's simply is not enough for any of us to say, well, we think it's extremely dangerous that once you allow it for terminal illness, the next thing you know, you'll be killing babies. You can't just put that statement out. You have to say, and here is some evidence there to support that. And the two main sources of evidence right now are the Netherlands and Oregon. And in each of those cases, there are a lot of people who've looked at it from an empirical point of view, and they tend to have disagreements about whether what's going on is good or bad. But the general consensus is that there are things to worry about with respect to the dying and euthanasia in the Netherlands. And the general consensus is There simply is no good evidence coming out of Oregon that there's a serious issue about terrible consequences.
So the question, Stephanie, was if we allow suicide under certain auspices, under certain circumstances, doesn't it ultimately lead to allowing it in all circumstances? And we gave the example of Belgium, where today, after it became legal in the 90s, eventually people are allowed to commit suicide because a loved one, a child, died, or because they're older than 70, or because they're losing their eyesight. So if we allow suicide under certain auspices, doesn't it lead to this slippery slope where eventually it will be allowed in all circumstances?
I think it certainly could. I think that we are looking at Oregon right now, who is looking at changing their definition of terminal to take out the 6 months portion and just having a condition that would result in your death. So while that hasn't happened yet, it's being considered. And as we slowly consider opening definitions further and further and further, at what point will it stop? So while it may not happen tomorrow, I do think it's possible, just as Canada was considering allowing assisted suicide for minors. So again, opening the door more and more each time. And again, when we look at the definition of terminal, we're saying 6 months to live with or without treatment. So that already opens the door further to people who we don't know for sure would die, because all you have to do is stop taking your regular medication and suddenly you're eligible. So I think that there would certainly be standing for individuals who want access to assisted suicide to say that person gets it and I don't, and that's not fair, and I want access to it as well. And it would go through our court system, and I can't tell you how it would turn out, but I can tell you that when we're looking legislatively, we are seeing definitions being expanded. And with that expansion, there is certainly a possibility that it could lead to where we see in Belgium that a deaf person could choose to kill themselves because they don't like being deaf, rather than providing suicide prevention services to people. We're providing suicide assistance when these individuals could live very happy lives. But because society has deemed that there must be something less valuable about them, then we should allow them to die. Very much like the movie Me Before You, that celebrates killing a person in a wheelchair who was living a pretty great life. He had just fallen in love. He was rich. Why would you want to die? And yet the movie celebrates this concept that disabled people should die and even romanticizes it. So with this kind of concept going around in our communities and society, I do not see why we wouldn't continue to expand definitions and allow this to happen.
Thank you very much, Stephanie. Our next question is as follows. Under what circumstance, if any, do you think it should be legal to help people who want to die peacefully? Under what circumstances, if any, do you think it should be legal to help people who want to die peacefully? If you think it should never be legal, does it follow that we should also prosecute suicide, or should we only prosecute people who assist people in ending their lives? There's a bit of an involved question, so I'll ask it again. Under what circumstance, if any, do you think it should be legal to help people who want to die peacefully? Is there any circumstance where it would be legitimate to assist people to die? If the answer in your mind is never, does it follow that we should prosecute suicide? Or should we only prosecute people who assist people in committing suicide? So,
may I answer that as the physician?
Everybody's going to answer that. We're going to start with David. You're right after him.
Well, if we're talking about doctors, doctors who are assisting their patients and who are compassionate, patient-centered doctors, will oftentimes do assist their patients in dying. They will help to withdraw life-sustaining treatment, whether it is a pacemaker or a feeding tube or a ventilator, and with the result of being death, and the patient intending that death result oftentimes because their suffering has become so great. The doctor's intention really isn't relevant. It's the patient's intention that really matters here. And so it's certainly appropriate for for doctors to be assisting their patients to end their suffering in a way which will result in death. Doctors also will assist patients in some circumstances who are voluntarily stopping eating and drinking, those who are in hospice where they will need care from a doctor or a nurse, social worker, etc., in order to achieve their goal of ending their lives. But that, of course, is not as good an option for some people as medical aid and dying, because it takes so much longer, to a week or 2 weeks oftentimes, before a person in fact dies. So there are circumstances where it's certainly appropriate for people to be prosecuted for assisted suicide. And in fact, probably most people should be in most circumstances, although there are circumstances, for example, where a person is dying, they are suffering terribly from their circumstances, and a loved one does help them in some way to die. And the question is whether or not that person should be prosecuted, convicted, and confined. Now, maybe it's appropriate in those circumstances for a person to be prosecuted and maybe even convicted. But those people who are acting compassionately on behalf of a patient who wishes to die probably in most circumstances should not be incarcerated, even if they may have committed a crime. And one of the leading experts in palliative care, and who actually helped his patient to die before there was a law in New York, and there's no law still in New York, was Timothy Quill, a doctor at the University of Rochester Medical Center, who actually helped his patient die and was prosecuted. But the grand jury, understanding what Dr. Quill had gone through in helping his patient, and after listening to him testify, decided not to indict him. And so he was never convicted of any crime, despite the fact that the assisted suicide law was on the books in New York, and we did not have a medical aid and dying law in New York at the time, and we still don't.
Joanne, please give us your answer.
I mean, you asked, in a sense, a sort of silly question. Of course we can help people who prefer a peaceful death. What is the alternative? To die in seizures? To die cursing? To die ranting? I don't know what the alternative is. Almost everybody dies peacefully, no matter how they die. So peaceful isn't the question. The question is, can you set the time and place of your dying? Or do you have to leave yourself subject to the vagaries of nature and the uncertainties of how much resilience your body has? And the question of whether it's peaceful, I mean, almost all hospice deaths are peaceful, with rare exception. Peaceful dying is not the question. The question is, can you control the time and manner of your dying? And even in a situation in which you're taking an overdose and deliberately aiming to end your life at this time, sometimes our calculations are wrong. Sometimes the person throws up the medicine, or they have more resistance than you thought, or for whatever reason, it just doesn't work as expected. So you have to kind of be ready for the response on that. The fact that Gerald says that this is a generalized problem about terminal illness and the boundaries, that doesn't make it easier. That makes it harder. There's tremendous friction about hospice care. Hospice was built on the idea that there were people who were dying, and they were different from the rest of us, who I call the temporarily immortal. And you could tell that you could tell this is a dying person. And the dying person was expected to, damn it, die on time. And if they managed to escape, they didn't live much longer. They still were dead within a few weeks. But it's very different when you're dealing with someone with a long-term degenerative illness. So a person who statistically is likely to die within 6 months, 51% likely to die in 6 months. You could still have 30% of that population alive in 2 years. There's a long tail problem. We didn't have that in mind when we were working on developing hospice programs. The early hospice programs were all highly predictable cancers. And yeah, some people were going to make it more than more than a week, more than a month, but they weren't going to make it a year. And now we have lots of people who statistically are within the hospice criteria, if it's 51%, but who could live 2 or 3 years with the same illness. It isn't like it went away. So this makes it very complicated and very difficult. And the audits that CMS does are mostly really troubled for this reason.
Thank you. Gerald?
First, I agree with almost everything that Joanne just said about the difficulties of defining terminal illness and the importance of trying to get clearer about that. As to the question you asked, I mean, it seems to me there are clear cases in which we want to have laws against assisted dying. We want to be able to prevent manipulations by relatives hoping to inherit from their parents or their father with helping them along, so to speak. We want to prevent people from volunteering to unhappy people that they will help them die. So there are clearly cases in which we need the criminal law in order to avoid those kinds of manipulations. It's also the case that there are clear cases in which it's perfectly permissible to assist a person in dying, and I think nobody disagrees. We all agree that if a patient on life support asks their doctor to be removed from life support, knowing that this will in fact lead to their death, and in fact intending that this lead to their death, that the physician has an obligation, not simply is it permissible for them to do so, they have an obligation to do so, and if they don't do so, they can be prosecuted for assault and battery. Basically, they're forcing a person to have a medical intervention which keeps them alive against their will. So there are clear cases on either side. Sometimes the question arises whether we should prosecute or penalize suicide itself, which seems like an absurd question. I mean, what more are you going to do to the person? But if he's successful. But of course, the Catholic Church has an answer for that one, which is you won't allow them to be buried in sacred ground. And I suppose if we were really crazy and wanted to intervene and after the person has successfully taken their own life, we could think of something similarly bizarre to do. Put up a wall in the cities listing the names of people who have successfully taken their own lives. I assume that nobody on this panel is in favor of that.
Thank you. So Stephanie, our question is, under what circumstance, if any, do you think it should be legal to help people who want to die to do so peacefully? If it should never be legal, does it follow that we should prosecute or punish people attempting to suicide? Or should we only prosecute people who assist people in committing suicide?
I think that we already help people die peacefully every day through hospice care, and that we have a hospice care system that works really well. We have palliative care that is really helpful for people. I think it would be silly to try to prosecute any sort of version of suicide because what is there left to do? But I do believe that when we're looking at prosecuting suicide, we need to there have been cases in Oregon that should have had a closer look, especially when you consider that when you take the lethal dose, a witness does not need to be present. So there's no requirement that a non be there to ensure that the dose is taken in a way that is voluntary on the individual, which means you could go and get that prescription with someone who is coercing you to do so, get it approved by 2 doctors, and then go home and have that lethal dose administered to you, as opposed to wanting to do it voluntarily. And without having any witness, how would anyone know that that's what happened? So there should be prosecution for people who are essentially murdering people. But at the same time, how will we know if there's no requirement for that witness? How will we know about that coercion? So I think that these are critical questions that we need to look into deeper, because there have certainly been cases where there was certainly financial benefit for the person who individual. I say helped very loosely because we don't know if that individual chose to die. There should be certainly more justice, but even if you do prosecute, the person is still dead in the end. So it does nothing for the individual who may have wanted to live and didn't get the opportunity to do so. And with the rise of elder abuse in our country, I think this is a concern that we need to take a lot more seriously, because people are harming elderly individuals and killing them now. Creating a legal path for this may just allow for more illegal circumstances to happen, but with a law that protects doer. And I think we need to think about elderly people and people with disabilities when we talk about this issue, and the abuse that can happen with that.
Thank you. And our next question is there a difference between actively helping someone die and is there a difference between actively helping someone die, giving him some kind of poison or whatever, and stopping a life-prolonging treatment? Is there a difference between actively helping someone die and between stopping a life-prolonging treatment? And if so, what exactly is the difference? David.
There really is no significant difference. When doctors withdraw a ventilator, they're really more actively involved in the patient's death than when they simply provide a prescription of medication for the patient that the patient may or not take him or herself at a time and place of his or her choosing. The doctor's not that much involved in the actual death of the patient so much as the doctor is involved in the death of the patient when life-sustaining treatment is withdrawn. So I think that people try to conflate, or not to conflate, that just to distinguish between the two sets of circumstances, but both result in death. For the patient, the intention is death. We don't know what the intention of the doctor is in any circumstance. The doctor may not wish the patient to have a ventilator withdrawn, but complies with the patient's wishes to have the ventilator withdrawn because that's what the patient wants. The doctor may not want the patient to take life-ending medications pursuant to a law which allows medical aid in dying, but does prescribe those medications with the hope that the patient won't take the medications, or vice versa. The doctor may think that the patient, it would be a good idea if this patient had their suffering ended and it's now timely to prescribe those medications, or the doctor may want the patient to die when he or she withdraws the ventilator. But I want to just also comment very briefly on what Stephanie said with regard to medications being administered by a loved one, supposedly, rather than the patient, and maybe forcing it. And she's absolutely right. That could potentially happen, but it could also happen when a person is in hospice, when they have lots of morphine in the home, which could be administered in the same way by either someone who wants to have the person die more quickly, or the patient him or herself does. But again, these are people who are going to be dying very soon no matter what. So it's not a matter of whether they're going to die. They are going to be dead soon. So nobody's going to be able to gain very much by simply having the person die a few days sooner than they might have otherwise if they were to engage in some kind of nefarious activity. And by the way, there is no proven case either in a court or administrative body or a medical board of any wrongdoing when it comes to the medical aid and dying laws across the country. And there's no evidence of coercion of people with disabilities, for example, in Oregon, according to the executive director of the Oregon Disability Rights Organization.
Joanne? Joanne, we can't hear you.
Okay, you can put these stories in the most positive light and say, well, it's only a few days, they'd be dead anyway. But the story that the community tells about the course at the end of life does matter. And the story of throwing off an unwanted medical intervention, like a ventilator, is a very different story than choosing to take a medication to end your life at a particular time. whether it's induced by others or freely chosen. So, I mean, there certainly are troublesome cases at the boundary. The question that Tomar asked was really about passive or active. And there are troublesome cases. The way to get rid of a ventilator in traditional Orthodox Jewish hospitals is to have the ventilators set to go off once a week, and they have to be restarted. So nobody actually has to take a step to stop a ventilator. It's built in. Well, I mean, okay, that fits the story of that tradition, but I'd find it a little awkward and kind of gimmicky. But most of the time, people in their natural language do differentiate from stopping a treatment which is getting to be annoying and burdensome and taking a lethal potion that is meant to kill you at a certain point in time. I mean, the very language around it is very different. So, they don't often conflate or cause a lot of of challenge. And we have long agreed that medical care cannot be arrogant enough to inflict itself upon people who do not want it. That the Jehovah's Witness can turn down blood transfusions and go on to heaven, despite the fact that every doctor standing around is in anguish over not being able to save this life. So we can defend that and know that it is different from a person coming in and saying, cut off my good right arm. I just don't want it anymore. No doctor would do that. And it would violate the patient's choice because the patient clearly wants it done. So, we have sort of cultural pathways that tend to be fairly serviceable in almost all but the most extreme of cases. And,
Sure.
we could have developed a way in which we said, no, you can't stop anything once started unless it's on a timer that turns it off on its own. But that isn't the way we developed it. That isn't the stories we tell. And we have our particular culture. And it's worth some defense.
Gerald.
I think these distinctions are interesting and important, and they are sometimes worth defense, and sometimes they are not. There are distinctions that doctors use to distinguish what they do in helping patients die from what is done when they give a prescription for a lethal medicine to a dying patient. Sometimes these distinctions hold up, and sometimes careful and critical examination of the distinctions show that although there might be such a distinction, it really has no moral significance. And I think one of the best examples to look at to try and figure out whether these distinctions make sense is the one in which the doctor, at the request of the patient, removes him from a ventilator, removes him from life support. Now, doctors are very reluctant to say that in that case they killed the patient. They insist that no, they let him die, that he dies from the underlying disease and not from removing him from a ventilator. And it seems to me that careful thought about this reveals that this is simply just false. For example, suppose that instead of the doctor removing him from the ventilator, it was the nephew who wants to inherit from the dying patient. Surely we would say in that case, he does exactly the same thing. He pulls the plug, he turns off the switch. Surely we would say in that case, he killed his relative, not that he let them die. And it seems to me that in both cases, everything is exactly parallel. The causal chain is the same. The intentions and motives may be different, but the question is, what caused the death of the patient? What caused the death of the patient was pulling the plug. And so I think we have to examine some of these distinctions, like the distinction between acting and failure to act. Sometimes it makes a difference, sometimes it does not.
Stephanie?
I would agree that sometimes it makes a difference and sometimes it doesn't. Particularly in this circumstance, if it is involuntary, it doesn't make a difference to me. If a person stops their life-prolonging treatment, but it wasn't that individual's choice, it was the nephew's choice, then there's a problem there, just as much as if the person isn't choosing to take the lethal dose, but it is being coerced upon them, or it is being done through abuse or any other matters. So for me, there is a difference when there is voluntariness to it. If a person wants to end their life-prolonging treatment, there is nothing to say you are forced to take on treatment. You have the choice to deny anything that you don't want imposed on you through medical treatment. But giving someone a lethal dose is a completely different thing. It is actively ending a person's life as opposed to allowing a person to die when they would have died without that treatment either way. And it is also putting on a different value to that life expectancy. Helping a person die actively brings their life to an end when it could have been much longer. Taking away that life-prolonging treatment is not doing anything to actively cause a faster death than if they hadn't had that treatment to begin with. So I think there is a significant difference, but there's not a difference if it was involuntary, in which case I'm still opposed, because anyone who doesn't say, yes, I want to die, shouldn't die. And for me, we're looking at a law that would allow some who do want to die the right to die, but it brings a danger of having so many others who don't want to die against their will. And I think that we need to evaluate how many lives we're willing to risk.
Thank you, Stephanie. Okay, so our next question is, do you feel that there is an inherent conflict with their primary role in society as healers in letting physicians help people die? Does it conflict, in your opinion, with the Hippocratic Oath? David.
Do you want me to answer or do you want Joanne to?
Yeah, I'm going to have to go.
Joanne, why don't you go ahead?
Yeah.
I don't care if it conflicts with the Hippocratic Oath. That was written 2,000 years ago. But does it create more anxiety in at least some patients as to what it is that we are willing and able to do? And surely it does for some patients. There are patients who are suspicious of our motives anyway, and perhaps the disability community is among the leaders in being worried about the motives that doctors have. So, if yes, among our armamentarium is the opportunity to see that you are dead, it's going to create some anxiety for some patients. And, I don't think that that's necessarily more widespread than the anxiety they feel that we're doing anything we do for personal financial gain, which is the way that our politicians now talk about doctors, as if they can control what it is we do by simple financial incentives. That's the most derogatory thing going, but it's a concern, and would need to be dealt with in a thoughtful way. And thanks for having me on, and good luck, Stephanie, in keeping up the argument.
Thanks.
Goodbye.
Thank you so much. Goodbye. David.
There actually is no conflict when it comes to a doctor's obligation to help his patient heal. And the reason is because at some point when the patient is dying, the doctor can no longer heal. And at that point, the doctor has to be concerned about the patient's suffering. And so in supporting the patient, the doctor should be hopefully referring that patient, if the patient already isn't in palliative care or hospice, to palliative care and hospice, because while the patient can no longer be healed, certainly hospice and palliative care can provide for the needs of the patient, whether it comes to symptom management or dealing with the patient's anxiety or depression or spiritual needs, whatever it might be, in order to ensure that the patient has the best quality of life as he or she continues to live until such time as he or she dies. So there really is no conflict at all with respect to the doctor's obligation to help the patient heal when the patient is at the end of his or her life. And in fact, a doctor is really doing what he or she should be doing when he or she prescribes life-ending medicines for a patient who requests them, who is terminally ill and mentally competent, and staying and not abandoning that patient by saying, well, I really can't do that for you in a state where medical aid in dying is legal. The doctor either should provide prescribed medications or refer the patient to a doctor who is willing to do so.
Thank you. Stephanie.
So I think that first, there is an inherent conflict, especially when we look at the definitions of assisted suicide that say 6 months to live with or without treatment. In that case, a doctor could help to heal an individual with treatment. But in actively choosing assisted suicide instead, you're not giving that treatment that could allow a person to continue living. And it also, assisted suicide could deter the medical advancements that we see through experimental treatments. Experimental treatments can continue to find new cures and also make a more life-prolonging treatments for all of us. But if we instead choose to allow people to die, instead of working on trying to find new solutions to live, then we lose that entire aspect and we could lose that medical experimentation. But second, I think the disability community is already skeptical of the doctor's commitment to the Hippocratic Oath. We've seen that studies show doctors value the lives of disabled people less. A study done by people with spinal cord injuries evaluated doctors treating people with spinal cord injuries and the spinal cord injury patients themselves, and asked each population to rate the life of the person with spinal cord injury on a scale of 1 to 10. The doctors were consistently rating their patients' lives 0, 1, 2, 3. None of the spinal cord injury patients rated their lives less than a 7 out of 10. So I think that right there raises questions of how much does the doctor care about the treatment of that individual if they don't value the life of that individual, and how much are they sticking to their Hippocratic Oath. And so if you don't value the lives of people with disabilities, then you are more likely to allow them to die and justify it by saying it's helping them, when in fact it's devaluing our lives and letting us go prematurely because society doesn't value the lives of disabled people.
Thank you, Stephanie. Gerald?
Well, following Tomar's advice, I believe that every definition of medically assisted dying uses a definition of terminal illness, which is 6 months to live with treatment or without treatment. Now, with respect to the general question, I believe that the function of a physician is to help them medically and to be their ally. That the primary function is to be an ally of the patient in their struggles with disease, disability, illness, and to help them in every way possible. So it seems to me the first obligation is to heal if they can. The second is, if they cannot heal, to alleviate the pain and suffering of the illness. And if they cannot do that, in the eyes of a patient who believes that they would prefer to be dead because they believe that death is better for them than the continued living of the kind that they are able to have, then I believe the final obligation of the physician is to be their ally and help them to die.
Thank you, everybody. So we're coming to our last question. Our last question is as follows. Could the normalization of suicide under certain conditions eventually lead to a societal expectation and pressure to commit suicide under these conditions? So could the normalization of suicide under certain conditions eventually lead to a societal expectation and pressure to commit suicide under these conditions? David.
The answer is absolutely no, because we now have 50 years of cumulative experience with medical aid in dying in the various states which permit it. And there's just no evidence that we have an increased rate of suicide, although suicide rates are increasing for various reasons, but not having to do with medical aid in dying. There certainly is not going to be an expectation for that of people that they should be committing suicide for any reason, because most people value their lives. As we talked about before, life is precious, and people do as Stephanie was saying, and I completely agree with her, people with disabilities have, which should be considered, which are valued by themselves and should be valued by others. They don't have an interest really. And so if you think about people who are really suffering to some extent and have a difficult life more so than some because of certain disability, whether mental or physical, that's their life. I don't think there's any reason to think medical aid dying that we expect people would start thinking about the devalued lives of people with disabilities by the medical community, by doctors, and by others, and continued discrimination. This medical aid in dying is not about people with disabilities. It is about people who are terminally ill, most of whom have not had serious disabilities before they became terminally ill, although they might have some now. And so they are making the decision to end their lives. They are taking the medications themselves if they decide to do so. No one is doing this for them. Nobody is ending their lives prematurely. And one of the concepts and precepts of the Americans with Disabilities Act is autonomy and being treated equally with everybody else. And so even if we're talking about people with disabilities at the time that they're terminally ill, they can make autonomous decisions for themselves with regard to how they're going to die. And if someone with disabilities wants to end their lives by taking the medications after they've been prescribed and after an oral request has been made and a written request, which is required by every law except in Montana where it's done by statute, that is their absolute right to do so. And we should not be prohibiting all dying people from exercising their right to medical aid in dying because there could potentially be problems with regard to coercion and exploitation. But again, there's no evidence that that's taking place.
Stephanie?
I think that I'm really glad that David brought up the point of being treated equally. The ADA does premise itself on equality, and when you are given a choice to die and not given a choice to live, then that's not being treated equally. And we have seen cases where a person has applied for life-prolonging treatment and has been denied by the Oregon Health Plan and instead offered assisted suicide. So that's not equal treatment to me. And I think that, yes, it can lead to a culture where assisted suicide might be expected. This brings me to my great-grandmother. She's 102 now, but on her 101st birthday, I asked her if she wanted to live to be 110, because oddly, that is how long her mother lived. And her response was, no, it's too much work for other people. So she didn't want to die based on pain. And I asked her how her life had been, and she said, it's been a great life so far. I don't want to be too much work for other people. And that is one of the top 5 reasons cited in Oregon as to why doctors are issuing the prescriptions for the lethal dose. Is one of the top 5 reasons are loss of autonomy, less able to engage in activities, loss of dignity, loss of bodily control functions, and feeling like burdens. So the idea that you're not in any pain, but you feel like a burden on your family, and that's why you want to die, the legalization could lead to the uptick of people choosing death, not because they feel any sort of significant pain or suffering, but they just don't want to be a burden on other people anymore. And that's a really alarming thing, that people would want to kill themselves so as not to inconvenience another human being.
Gerald?
I'm going to break the rule and disagree with David, but only because we actually agree completely. It's a matter of semantics. Could these terrible things happen? Of course they could happen. It's logically possible that they might happen. Could I win the lottery? Of course I could win the lottery. It's just extremely unlikely. Would I win the lottery if I bought a ticket today? I'm not very confident of that. So the question is not, could terrible things happen as a result of this legislation? The question is, would it be likely that these things would happen? And here I completely agree with David that on all the available evidence that we have in the United States, given our culture, given our history, that it's extremely unlikely that it would happen. If you could convince me that it was likely, that it was probable, I would have my doubts then about legislating medically assisted dying. But since I believe all the evidence indicates that these are not likely to happen, I believe my support is positive.
So thank you very much, David, Stephanie, Gerald, and Joanne. It's been a wonderful conversation. I think this is a very complex topic, a very potentially polarizing topic. And I think you've all done a stellar job of listening to each other, respecting each other, and just adding your meaning into a common shared pool, which is our purpose here in Roundtable Conversations. I'd love to talk to you all in the future. I hope you had a great time as well. I hope our audience enjoyed it. And that just about sums it up. Does any of you want to add any last words, any last going away points before we wrap this up? David?
Yes, I would. I think the importance of this issue is this. There is now a large body of evidence compiled over half a century, essentially, in states where medical aid in dying is legal, which shows conclusively that medical aid in dying is a rarely used but an ethical medical practice which is safe and causes no harm to anyone. So the bottom line should be that even if you are personally opposed for some reason, we should not be making policy based on individuals' thoughts about this, and rather we should be allowing people to exercise this end-of-life option if they choose to do so.
Thank you. Stephanie, last words?
I completely agree with David. We should not be making policies based on people's thoughts about this. We should be making policies based on what the danger would be to other people. Just as we look at gun control over what is a person's right to have access to something versus the harm it can cause to others, we should have that same value when we talk about assisted suicide and the harms that it can cause some of the most vulnerable people in our nation, from being denied access to the treatment by insurance companies, from abuse, from financial distress. I'm actually, I think that we're not supposed to disagree. So even I think a violation of the rules. So I think
Got you.
that it's important for us to recognize that there is real harm to real lives. And if we lose even one life that didn't want to die, is it worth it? Do you say in the end, well, the majority of people did want this, so it's okay? I don't think we do, especially when we leave so many people who are already vulnerable and already experiencing abuse to be victims of this. And of course, I understand David's point that there's no criminal prosecution of this yet, of any malice or wrongdoing. But how could there be if you have a law that sanctions assisted suicide? Why would there be an investigation if there's a law that says that this is okay? So it really does protect bad actors who would administer that lethal dose without that witness, and nobody would know, and there was no reason to investigate it.
Thank you so much. And Gerald?
Stephanie mentioned two possibilities. It's possible that the Oregon definition of terminal illness will be expanded, and then it's possible that if it's done, that will be harmful. I find it encouraging, actually, that there has actually been not a single case of expansion of the definition of terminal illness in any of the 7 or 8 states and the District of Columbia where we have such laws. So I will say this to Stephanie: when and if Oregon expands its definition of terminal illness, I will like to have another discussion with her, because then I would start to be a bit worried along the lines that she mentions. It still, of course, is the case that it might be expanded, but expanded in ways which are legitimate and good and not harmful. And that's a second possibility that we have to consider. So I look forward to not seeing the Oregon definition expanded, but if it is, I would like to continue the conversation.
Thank you so much, everybody. This was a magnificent conversation. I have many more questions, but regretfully, we are totally out of time. Maybe we'll have a chance to do this again in the future. I hope everybody found it enriching. If anybody still has questions, wants to continue the conversation, you're welcome to post in the comments below. I'll also post in the description how to reach out to all of the speakers if you want to continue the conversation with them. And that's about it. I hope you all have a wonderful day and continue to promote and practice the art of listening. Thank you much. Thank you very much, everybody. Bye.
Thank you.
Thank you.
Good night.
Good night.